Hello and welcome to the Herrington Carmichael Employment Law Update for May 2019. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael. As always, I've got the 4 key updates for you from the last month. Where do we start? Directors' personal liabilities. The case of Antuis and DJ Houghton came out this month. What this case related to was a failure by the employer to pay the correct amount of wages. The employer actually breached the statutory duty to do so, and as a consequence the directors had personal liability. They couldn't hide behind the corporate entity. This is quite worrying for businesses who don't comply with their obligations. So do comply with your obligations and pay the right amounts. Next, bonuses, the case of Bluestone Medical and Swinnerton. In this case there was a bonus scheme that became sufficiently certain to move it from a discretionary scheme to a contractual scheme. Now the facts of the case are convoluted, but what you have to take from this is clearly where discretion is included, a court is taking quite a liberal approach to that, and actually where there is a certainty as to the terms, those terms can have contractual effect. What should an employer do? Look very carefully at discretionary bonus schemes. If it is genuinely discretionary, treat it as discretionary. Thirdly, permanent health insurance terms. In the case of ICTS and Visram. This case related to the benefit of permanent health insurance. This is a recurrent income for an unwell employee. And the terms of the scheme weren't sufficiently clear. What they said was that the scheme should apply until there was a return to work. And the court had to interpret what return to work meant. In this scenario, the court held that return to work meant retirement or death, one or other. And actually in the case here, the individual was never going to be able to return to work and actually got the entire benefit of the permanent health insurance all the way up to retirement. An excellent benefit for an employee. For an employer, however, look very carefully at your PHI benefit terms. You may find yourself being stung for quite a hefty bill. Finally, injury to feelings awards have increased again, so this is the award that an employee receives if it is found their employer has committed some form of discrimination, and it's awarded as to the extent of the injury to feelings they have suffered. The lower band has gone up to £8,800, the middle band has gone up to £26,300, and the upper band is up to £44,000. Quite a considerable sum, but please remember, the upper band cases are very, very rare. That's it from me this month. I'll come back to you in June, and until then, I hope you have a good summer. Thank you.